the claimant from the 15th day of January 2019 to the end of his tenure of employment on the 3rd of February 2022. E. An order prohibiting the defendants from further withholding or refusing to pay claimant his salaries, allowances, and emoluments which have accrued since the 15th day of January 2019 to the end of his tenure of employment on the 3rd of February 2022. F. An order of this honorable court for the payment of interest by the defendant to the claimant at the rate of 21% per annum for all the sums of money which have accrued and become payable to the claimant from the 15th day of January 2019 till the date of judgment and the final liquidation of the entire judgment debt. G. And for such further other orders as this honorable court may deem fit to make in the circumstances. On the 8th of November 2022, the defendants filed their statement of defense, and following the amendment of claimant's complaint commencing this suit, the defendant on the 30th day of May 2023 filed amended statement of defense. On the 9th of November 2023, the claimant testified in proof of his case as CW1. CW1 adopted his witness statement on oath as his evidence. In this case, he also tendered 10 documents in evidence. One of the documents marked as Exhibit C1 was admitted in evidence without objection, while the other remaining documents marked as Exhibit C2 to C10 were tentatively admitted in evidence as counsel for the parties were to address the court on the admissibility of the said document at address stage. CW1 testified that he is a farmer. Under cross-examination, CW1 testified that he is a farmer but cannot say the number of years he had been in farming business, but he stated that it is over 20 years. CW1 continued his evidence under cross-examination to the effect that he was appointed in 2019 as president of the customary court Okuku, Yala local government area of Cross River State, with 2 members, namely Hilary Oga Aju and Malaki Oga Idu. They rendered the report through the registrar of the court but cannot remember the name of the person to receive the report. That they have been submitting reports. He does not have copies of the report made. The reports were submitted on monthly basis, except Exhibit C6. Nothing shows it has been submitted. He was employed on grade level 5 for 3 years. They worked, but no pay. They worked till 2022. There was nothing in 2020 and there was nothing in 2021. They were going to work and they were not paid. Exhibit C4 was not addressed to him. Exhibit C2 is a document given to the claimant. The letter was not smuggled. Exhibit C2 belonged to him, belonged to the claimant. He was duly captured. Exhibit C8 and Exhibit C10 are public documents for everybody. The amount stated in his claim is what the claimant is expecting. They stopped work in January 2022. They made the report to zonal records. The record case book are there to testify that they worked. On the 25th day of January 2022, the witness of the defendant, one Peter Samuel Ina, testified as DW1. DW1 adopted his witness statement on oath as his evidence in this case. No document was tendered through DW1. At the conclusion of his evidence in chief, DW1 was cross-examined by the counsel for the claimant. Thereafter, he was discharged. Under cross-examination, DW1 stated that his name is Peter Samuel Ina. Exhibit C1 was read by the witness. DW1 stated that by the Exhibit C1, claimant was employed by the defendant, but he does not know if he worked. It is not their practice to employ and not to payroll payment of staff is made by the head of service. He did not agree if offer of employment is given, one is entitled to salary. He does not know if claimant had been paid or not. By nature of the claimant's employment is entitled to salary. The case of the claimant. I shall skip reading the case of the claimant. I will also skip reading the case of the defendant. Then I go to the submissions of the defendant, where a single issue was formulated and argued by Maureen Inkiri, the Deputy Director of Litigation. I will also skip reading the submission, but I have captured it in my judgment. I will also skip reading the submission of the claimant, where Elizabeth O'Connor canvass argument in respect of the single issue formulated, which was argued based on points. But I have captured the argument in the body of the judgment. I now go straight to the decision of the court. I have considered all the processes filed by the parties, the evidence laid at the trial, and the written and oral submissions of counsel for the parties. It is clear to me that the main claim of the claimant is for payment of his unpaid salaries for 36 months for services he allegedly rendered to the defendants based on his employment as per Exhibit C1. However, before delving into the determination of claimant's entitlement to payment of his unpaid salary for 3 years, which he had, I shall endeavor to first and foremost deal with the issue of admissibility of Exhibit C2 to C10. The counsel for the defendant has stoutly argued that apart from Exhibit C1, letter of appointment, all other exhibits are inadmissible. According to counsel, Exhibit C2, C3, C6, and C10 are public documents and ought to have been certified, but were not certified. It is also the submission of counsel that Exhibit C2, C5, and C8 are private documents under Section 103 of the Evidence Act. Counsel continued his submission that Exhibit C2 was undated and unsigned. This has made it inadmissible in law. Exhibit C5 and C8 are letters purportedly served on the defendant, but there is no acknowledgement to show defendants were actually served. Counsel contended that there is a strong indication that they are not authentic. They were made merely in anticipation of this suit. For counsel for the claimant, Exhibit C1 to C10 are all documents of the defendant. The claimant gave notice to produce the originals as required by the rules, but the defendant refused or neglected to do so. They cannot be allowed to benefit from their own wrong. On Exhibit C2, counsel submitted it was tendered to entertain claim of the defendant that the reconstitution of the district court approved by as per Exhibit C3 were constituted and inaugurated as per Exhibit C2. Exhibit C6 list of cases is original, need no certification. Exhibit C7 is to aid court to determine claimant salary. Exhibit C8 to C10 are all documents brought by the claimant to show to court that he did his due diligence to ensure that his salaries were paid to him. Counsel also argued that if this court is minded in holding the documents to be inadmissible, the court should do substantial justice and not allow technicality to cloud justice. Let me say here that giving of notice to produce does not operate to relieve a party of the burden of producing the document he wants to rely on in proof of his case. All that notices to produce postulate is that the party giving notice has secondary evidence of the document to which notice to produce was given. and in the absence of the original, secondary evidence is tendered by the party wishing to rely on the document to which he gave notice of it to be produced. The law is settled that notice to produce on the adverse party does not compel the party served to produce the document. Rather, it entitles the party serving the notice to adduce secondary evidence of the document in question. In other words, the service of a notice to produce a document does not relieve the person of serving the notice the burden of producing the document. If the case if he can, or of proving its content. Consequently, the non-response to a notice to produce by the defendant in this case will only entitle the claimant to tender secondary evidence with him. See the case of Buhari versus Obasanjo. In the event of a party refusing to produce document on which notice to produce was given, the proper procedure to be followed is, as a result of the failure to produce the document, is for the party that need the document to adduce secondary evidence of that document in accordance with Section 90, subsection A and 91 of the Evidence Act, or ask the court to compel the defaulter to produce the document by committal to prison. In the case at hand, a careful perusal of exhibits C3, C4, C7, and C9 and C10 will show that by the Section 102 of the Evidence Act as amended, these exhibits are public documents. For them to be admissible in evidence, the claimant is by law required to tender original or certified true copies of the document. In other words, original copies of public documents themselves are admissible. However, the only pieces of secondary evidence a result of the original of such public document that are admissible are the certified true copies thereof, but no other secondary evidence is allowed. In other words, in the absence of original documents themselves, only such properly certified copies are admissible in secondary evidence of which public document has no other kind of secondary evidence. See the case of Minister of Land versus Azikwe, see Omuburuke versus Esiage, see Araka versus Ebue, and host of other cases cited therein. In Ogwonu versus Amcom, the Court of Appeal Pa Mohammed Garba JSC, now JSCA now JSC, held that, I quote, the law is also now common knowledge that the only type of secondary evidence of a public document within the only type of secondary evidence of a public document admissible is evidence as proof of content of a document is certified true copy thereof in line with the provisions of Section 105 of the Act. No other type of kind or category of content of such document or for the purpose of judicial adjudication by the court of law is allowed. See Powdy versus IGP. See also ACB PLC versus Ahamba. But see also Ahamba versus Nigerian Army and another. The counsel for the claimant has insisted that notice to produce was served on the defendant as per pleading of the claimant, and that entitles the claimant to rely on secondary evidence in result of exhibit tendered in evidence. However, a careful perusal of Exhibit C3 addressed to Chief Magistrate at the purported swearing-in ceremony of President members of District Court on 25th day of February 2019. Furthermore, there is no evidence to indicate that the claimant has applied for certification and it was refused. There is also no evidence that claimant has taken steps to compel production of the document before the court. The lackadaisical attitude exhibited by the claimant in failing to do the needful in procuring the document he wants to rely on is fatal to the admissibility of the public documents sought to be tendered before this court. They are not admissible in law for not complying with the provisions of the Evidence Act. For Exhibit C2, employee information, and Exhibit C6, list of cases handled, they were not signed to authenticate them. Therefore, they are not admissible in evidence. As unsigned documents have no evidential value in law, they are worthless pieces of papers before the court, and they cannot be admitted. Furthermore, I note that Exhibit C2 was tendered in proof of assertion that the claimant has been verified as employee of the defendant, but this document betrayed the assertion as it is clearly stated in an activation column and verified. This means the claimant has not been verified. So even if admitted, the document has no evidential value to prove anything before the court. On this point, the decision of the Supreme Court in the case of Omega Bank Nigeria PLC versus OBC Limited, Toby JSC of blessed memory, where he held, I quote, a document which is not signed does not have any efficacy in law, as held in the cases examined. The document is worthless, and a worthless document cannot be efficacious. End of quote. Moreover, in Fine Bong and another, Oyewole JCA held that an unsigned document is totally worthless and incapable of comparing any title. In the more recent case of Raji versus University of Ilorin, and as it was held, an unsigned notice of appeal was held to be defective and invalid and rendered the appeal to be incompetent. Also in Uzokulo versus PDP and others, it was held that an unsigned document is a worthless paper, it is inadmissible, and where admitted, it cannot be relied upon by the court to resolve any controversy between the parties, as no weight or probative value can be attached to such unsigned document. See also the case of Alhaji Umaru Aliyu, Technical versus First Bank of Nigeria and another, where it was said that a document which is not signed does not exist in the eyes of the law. In effect, it is worthless and can neither be admitted nor be enforced. Section 168, subsection 1 of the Evidence Act does not avail the defendant because the document is not substantial, regular, and no presumption can be made in favor of unsigned. Exhibit C5 is pre-action notice. Counsel for the claimant has in his submission before the court argued that Exhibit C5 is surplusage. It was tendered to err on the side of caution. This means the claimant is not certain about the requirement of issuance of Exhibit C5. It is a product of guesswork and is not relevant to the claimants. In the circumstances, having found Exhibit C5 to be irrelevant, it is hereby discountenanced for purposes of this judgment. It is clear to me that the submission of counsel to the defendant it is clear to me that the submission of counsel for the defendant in paragraph 403 of the written address is attempt of counsel to give evidence which is not the function of address, There is no pleading in the defendant's pleading on subsequent issuance of letter of appointment after issuance of the first offer of employment. It is tried parties are bound by the pleadings. Defendants have not pleaded issue of subsequent letter of appointment. Therefore, they are not entitled to give evidence in their address as counsel has attempted to do. It is well settled that a party is not entitled to depart from his pleading and is confirmed to lead evidence in respect of matters pleaded, and any evidence which is not supported by the pleading goes to no issue. The counsel for the claimant has submitted that it is very clear from XBC1 that the third defendant, on the instruction of the direction of the first defendant, employed the claimant to work for her on authority of Umera versus NRC. Some obligations flow from the defendant to the claimant on the basis on this basis, chief of which is the payment of allowances and salaries. The claimant herein was appointed on grade level 5 from XBC7, which is a structure of judicial staff salary. His salary level is 05 and is 25,981 naira 58 kobo per month. Counsel continued his submission that the claimant, in his written statement on oath, gave evidence of how he was employed by the defendant, and he worked diligently for 3 years without being paid. Even during cross-examination, CW1 stood his ground that for 3 years that he was employed, he carried out his duties effectively, that Exhibit C6, which is the list of cases, was tendered to prove that claimant actually handled cases. Counsel continued his submission that even under the heat of cross-examination, the claimant still maintained that he worked diligently for those number of years that his appointment as president of Kaku District Court Yala local government area listed. Counsel for the defendant had argued in their final written address that the claimant did not bring any document to prove that he worked for those 3 years to be entitled to payment of salaries. For counsel for the claimant, as during the pendency of the claimant's appointment, the defendant did not query the claimant for any misconduct and did not carry out his duty, and that he did not carry his duties diligently or even at all that will warrant the non-payment of salaries in these 3 years. Besides, they are the ones that are alleging that claimant did not work for 3 years. That is why he was not paid. The onus is on them to prove allegation. It is right law that he who alleges must prove. The assumption of counsel for the defendant in his submission to the effect that the mere fact that the claimant was employed in the first place entitled him to paid salary seems to have been oblivious of the fact that in law, wages are paid to employee for work done or services rendered. As the employee has no obligation of paying for services not rendered. See Olatunbo Bosimba Nasa, see also Unwafo versus Anambra State. Thereafter, it is wrong. It is wrong and great misconception to assume that once employed, an employer must be paid. The counsel for the claimant is also wrong in his submission that the defendants who asserted that the claimant did not work or render services to them have the onus of proof. The law on burden of proof is well settled by a long line of decided cases that The initial burden of proof is on the claimant who makes the assertion. It is the duty of the claimant to prove every abatement in his pleadings, particularly where issues are duly joined on such pleadings, as in the case at hand. Where no satisfactory evidence is laid in proof of any fact in issue, the court would be entitled to dismiss such issue. In the instant case, the claimant asserted that he worked for 3 years and entitled to be paid salaries for 3 years, i.e. 36 months. This means the claimant, in fact, the claimant in the face of the denial of the dependent claims of the claim that the claimant serves them for 3 years is duty bound to adduce cogent credible evidence in proof of his assertion for working for the defendant for 3 years. The claimant in his evidence merely stated that he worked for 3 years without any concrete proof of service rendered. Exhibit C6 having been discountenanced for having no evidential value due to absence of signature to authenticate it. Counsel The burden of proving rendering service is on the claimant who asserted that he served the defendant for 3 years. It is when this burden is discharged that the burden will shift onto the defendants. This is because the law is well settled that the legal burden rests upon a party, whether claimant or defendant, who subsequently asserts the affirmatives of the issue. It therefore means that whoever asserts the affirmative or the positive of the It therefore means that whoever asserts the affirmative or positive of a fact is the one that has the legal burden to prove that assertion. This is based on the Latin phrase "el incumbit probatio, qui sit non quid neget camfa naturam pactum negatum probatio nulla." Sit, which means the proof lies upon him who affirms, not upon him who denies. Since by the nature of things, he who denies a fact cannot produce any fact. See Elemo versus Omolade. See Abu Bakr Abdullah and another versus Honorable Yahya Sadauki. See also Apollyon versus Alio and host of other cases cited therein. In the case at hand, the claimant is one that asserted the positive, i.e. that he served the defendant diligently. The onus is on him to prove this positive assertion and not the defendant who asserted the negative that claimant did not serve the defendant for 3 years. Counsel for the claimant has precariously has argued that the claimant is entitled to payment of 3 months' salary, 3 years' salary for service rendered to the defendant. However, the claimant has not stated the kind of service he rendered for him for the 3 years period. The claimant, in his further attempt to prove that he was duly employed and accepted his appointment to serve as president of District Cook Okuku, tendered Exhibit C3 as evidence that he was sworn in to function as president of the court by Patience D. Etim, Chief Magistrate, Esquire, Chief Magistrate Grade 2, who was said to have represented the governor at the oath-taking inauguration. I have earlier found Exhibit C3 inadmissible in law, being a photocopy of public document, i.e. Even if Exhibit C3 was found not to have been inadmissible, it cannot by any stretch of imagination prove that the claimant was sworn in as President District Court of Kukuyala local government area of Cross River State for him to assume office. This is because the law establishing district court has made it ample provisions on the way and manner a president district court can be sworn in and who can perform the swearing in. I have no doubt in my mind from the pleadings and the evidence I have no doubt in my mind from the pleading and evidence that the claimant was by the Exhibit C1 offered appointment as President District Court of Kukuyala local government area of Cross River State for a period of 3 years. But the claimant has not been able to establish that he was sworn in as President District Court of Kuku as required by law and assumed duty as Exhibit C3 is not in compliance with the extant provisions of Section 78 of the District Court Law of Cross River State, which governs oath of office of district president and members of district court. See Section 78. The above quoted provisions of District Court Law Cross River State on oath of office is very clear and unambiguous. This section has made it compulsory for oath of office to be administered by the Chief Judge or a judge of the High Court and not a magistrate, as in the case at hand. On the claim that the claimant has worked for 3 years and handled several cases, the claim has not been proved by the claimant as Exhibit C3 and C6 cannot assist the claimant in that respect due to lack of evidential value. Furthermore, having established that claimant was not legally and lawfully sworn in as required by the district court, has no bias to sit or handle any case. If the claimant has done so, it is at his peril. The absence of evidence of oath of office also goes to prove that claimant had not accepted appointment as President District Court or Kuku, Yala local government area of Cross River State. From all I have been saying above, the claimant has not been able to prove his case on balance of probability, as there was no evidence to show he actually worked for the defendant, since he was not sworn in for him to assume duty as President of Kuku District Court. The claimant, having woefully failed to prove his case, he is not entitled to any of the relief sought. The claim is accordingly dismissed for lacking in merit. Judgment is hereby accordingly entered.
As the court pleases.
Yes, call the next.
Okay, my lord.
I said counsel trying to talk. You are muted yourself. You unmute yourself. I can't hear you. Unmute yourself. Counsel, unmute yourself. You have muted.
All right, my lord, I have unmuted. I have unmuted, my lord. Can I announce my appearance, my lord?
No, you can hear me now.
Yes. One by one after
my lord,
we
with profound humility. Yes, my lord. With profound humility, my lord. M.A. Nkiri,
yes.
DDCL. My lord, appearing with me are Martha Henshaw. Martha Henshaw.
Yes.
SC2. SSC2.
Yes.
My lord.
Yes.
And
yes.
Gede Itam.
Who?
SSC2. My Lord, Kede
No,
Itam.
the second name.
Senior State Council 1. Second is Martha Henshaw, SSC2.
Yes, I have recorded Martha Henshaw, SS2, SC2, sorry. Then
Yes,
you
my
say
Lord.
something,
And
Peter. What is this?
Kede
Kedei?
Itam, K-E-D-E-I. Itam.
K-A-D-E-Y-I. Kedei
Brand.
Peter. What is his designation?
Yeah, Senior State Council 1, my Lord. My Lord, we
Okay.
appear for all the defendants.
It's all right.
Thank you, my Lord, for that well
Yes,
researched
you're welcome.
judgment. We really appreciate.
It's all right, you're welcome. Yes, counsel.
May it please this honorable court. I.J.
Yes, sit down, sit down.
My Lord, I.J. Udiande.
You, IJ
Yes, my
Indian.
Yes, ma'am.
Are you appearing for who?
Yes, my appearance is for the claimant.
Are you appearing
For the
for
claimant.
the claimant?
Appear for,
Okay.
my Lord, we thank you for the effort in
Yes,
delivering
registrar.
My lord.
Registrar.
Yes, my
Call the
lord.
next case.
Okay, my lord. Suit number
Go ahead.
Suit number NICN CA between Mr. Abon of Cross
Please,
River
there should be no noise. Please, there should be no noise. We are in court.
Mr. Monkong Stephen Abon and the government of Cross River State to the Attorney General of Cross River State. 3. Cross River State Judicial Service Commission. My lord, the parties are absent.
Parties are absent.
Yes, my lord, all absent.
Appearance.
May it please this honorable court.
Appearance.
May it please this
Yes.
honorable court. I.J.
Yes.
Udiande. My Lord, I appear for the claimant.
IJ
Udiande, my Lord.
IJ
Udiande. My appearance for the claimant.
Yes, any other appearance?
Yes, my lord. Most
Yes.
respectfully, my lord.
Yes.
Deborah, okay.
Deborah, okay.
Senior Deborah Ada, okay, my lord.
You say?
Deborah Ada, okay, my lord.
Okay. Deborah, Ada, okay. Ada, is it A-D-A-H or A-D-A?
ADA, my lord.
Okay. Yes.
Senior State Council 2.
Okay. Appearing for who?
I pray for all the defendants, my lord.
Are you appearing alone?
Yes, my lord.
Okay. This is the judgment of the court. The claimant commenced this action against the defendant on the 24th day of October 2022. Thereafter, the claimant, with the leave of court, amended his general form of complaint and the accompanying processes. The amended processes were filed on the 16th day of May 2023, wherein the claimant claimed against the defendant as follows. I'm going to skip reading the reliefs or the prayers. They have been captured in the body of the judgment. Then I go to the case of the claimant. I will also skip reading it. The case of the defendant, I skip reading it. I go to the submissions of counsel for the defendant, where he formulated one issue. I have captured the argument in the body of the judgment, so I will skip reading the submissions. I go to the submissions of the claimant, where the sole issue formulated by the defendant was adopted with minor modification. The argument of counsel for the claimant have been captured in the body of the judgment, so I will not read the submissions. I now go straight to the court's decision. I have carefully considered the processes filed, the evidence laid by the parties. I have also reviewed the submissions of counsel in their respective binary written addresses. The duty to be performed by the court is to examine the case put forward by the parties and see whether, in the light of the law, evidence adduced the claim is sustainable. The Supreme Court has, in the case of Gabriel Atibi versus Kabel Metal, held that a claim is circumscribed by the relief sought, and the duty of the plaintiff is to adduce such evidence, material evidence, as are necessary to sustain the relief being sought. Furthermore, issues in a case are circumscribed by the claims before the court, as constituted by the press. All arguments and findings not related to the press are amiss. See the case of Salami versus Roma Bank PLC. This presupposes that all the argument, especially by the claimant, to the effect that his employment is with statutory labor, all goes to no issue unless tied to any of the relief claim. The argument on statutory labor having not been made, having been based on no relief being sought, cannot be canvassed in this case. This means the issue of employment of claimant as statutory labor does not arise, as there is no claim on it. For avoidance of doubt, the main claim before the court centers on payment of arrears of 36 months of unpaid salaries. Let me say here that the facts leading to the institution of this suit by the claimant are plain and straightforward, as borne by the pleadings of the parties and witness statement on oath adopted at the trial. The claimant's case is to the effect that he was appointed member 1, Unkum District Court, Ogoja, by the Exhibit C1 for a fixed period of 3 years, beginning from 4th of April 2019. The claimant claimed to have been sworn in and assumed duty and diligently performed his duties of adjudication, in which he handled cases for the period he served the defendant as per Exhibit C3. According to the claimant, for the period of 3 years he served, he was not paid salary by the defendant, despite having been verified as an employee as per Exhibit C4 and C6. The defendants, on their part, admitted that the claimant was issued with Exhibit C1, but there was no constitution of the district court. Therefore, claimant did not serve as claimed. The defendants also challenged the admissibility of Exhibit C2 to C10. Before proceeding to determine the claim of the claimant, I shall endeavor to scratch out the objection of the defendant to the admissibility of Exhibit C2 to C10. Counsel for the defendant refers to Exhibit C2 and 10 and submitted that these documents are public private documents. They are not admissible. They should be expunged from the record of the court. The document requires certification for them to be admissible in evidence, but they were not, and that they were not certified. For the private documents, they are photocopies and no foundation was laid for their admissibility. The only admissible document is Exhibit C1, which is the original. Counsel also argued that Exhibit C4, claimant verified employment details, did not have a date and the signature of the verification officer. It ought to have been signed in both for it to be authentic. In his response to objection,
Talking.
The response to the objection raised by the defendant to the admissibility of the C2 system, counsel for the claimant submitted that the hallmark of admissibility is relevance. As relevance determines admissibility, once evidence is relevant, court is bound to admit the evidence. According to counsel, Exhibit C2 to 10 are documents of the defendant. The claimant gave notice to produce the original as required by the rules. It is not correct. Claimant did not give defendant notice to produce. Counsel asked the court to look into the file and the pleadings of the claimant. The defendant refused and neglected to do so. Now they are crying foul. Counsel also submitted what the claimant did in this case is that upon failure of the defendant to produce documents, they were put on notice to produce claimant tender secondary evidence. The counsel for the claimant, in response to the objection of the defendant on admissibility of Exhibit C2 to 10, tried to weave sentiment. Counsel should know that doing justice means by doing justice means the court following the due process. If the law has chartered a path to be followed in doing justice, that path must be followed. The objection of the defendant is based on issues of the Evidence Act. Therefore, the submission of counsel asking for the court to do substantial justice means doing justice according to law and not according to whims and caprices of sentiment or sentimental justice. The rule as to notice to produce is well settled by a long line of decided cases that need no mention. A party on whom a notice to produce document is served is not under any obligation to produce the said document. The service of notice to produce only entitles the party serving notice to adduce or produce secondary evidence of the document in question by virtue of Section 89 and 90 of the Evidence Act. Failure by the party to produce will not cause the court to invoke the presumption of withholding evidence under Section 167D of the Evidence Act against the said defaulting party. See also the case of NNB PLC versus Onavulu. See also Buhari versus Obasanjo. The proper procedure to be followed as a result of failure to produce document is for the parties that needed the document to adduce secondary evidence of them in accordance with Section 90, subsection 1 and 91 of the Evidence Act, or ask the court to compel the defaulter to produce the document by committal to prison. There is no doubt by Section 102 of the Evidence Act as amended, Exhibit C2, C3, C5, C6, C7, and C9 are public documents. For them to be admissible in evidence, the claimant is required to tender originals or certified true copies. In law, the only acceptable admissible secondary evidence of a public document is certified true copy of the document in question. See Section 91 of the Evidence Act and the case of Araka versus Egwe. In Obonu versus Amcon, the Court of Appeal has this to say: the law is now common knowledge that the only type of secondary evidence of a public document admissible in evidence as proof of the content of the document is certified true copy 0, in line with the provisions of Section 105 of the Act. No other type or kind of category of secondary evidence of a public document is admissible as proof of the content of such document for the purposes of judicial adjudication by a court of law. See Pauni versus IGP. See also Ahamba versus Nigerian Army and another. The counsel for the claimant has insisted that notice to produce was served on the defendant as per the pleading of the claimant, and that entitled the claimant to rely on secondary evidence in respect of exhibit standard in evidence. A careful perusal of exhibit C2, C3, C5, C6, C7, and C9 will show that they are photocopies are not certified through copies, as there is no certification by public officer in whose custody the document are. This means that these documents are not admissible in law, even though relevant to the proceeding, because they did not comply with the clear provisions of the Evidence Act on certification. Furthermore, there is no evidence to indicate that the claimant has applied for certification but was refused. There is also no evidence that the claimant has taken steps for Exhibit C4. This is employee information. The document has no author as it was not signed. It was also not dated. The absence of signature and date has rendered Exhibit C4 valueless, as it has no evidential value in law, as its authenticity is in doubt. Therefore, Exhibit C4 is hereby discountenanced for the purpose of this judgment. For Exhibit C5, for Exhibit C5, this is a document that is supposed to have been signed and was not signed. The law is humble that an unsigned document has no evidential value, as it is worthless as far as the law is concerned. Furthermore, I note that the document was tendered to improve was tendered in proof of the assertion that claimant has been verified as employee of the defendant. But this document betrayed the assertion, as it is clearly stated in activation column of the document that unverified. This means the claimant has not been verified. So even if admitted, even if the document is admissible, the document has no evidential value to prove anything before the court. In the circumstances, Exhibit C5 is also hereby discountenanced for the purpose of this judgment. Exhibit C8 is pre-action notice. Counsel for the claimant has, in his submission, argued that Exhibit C8 is surplusage tendered to err on the side of caution. This means the claimant is not certain about the requirement of issuance of Exhibit C8. For Exhibit C10, it is later addressed to the then governor of Cross River State, complaint of non-payment of stipend to district court members. Now what is left to be considered in Exhibit 3? This is Exhibit 3. This document is said to be list of cases handled by the claimant between 2019 to 2022. It is clear to me that this document was prepared by any was prepared by anybody or person as it has no author. Nobody has signed it to authenticate it. Being unsigned is not admissible in law. It is hereby also discountenanced for the purpose of this judgment. I now turn to the substantive claim of the claimant. It is evidence from the processes filed and evidence of the parties that the main grounds of the claimant is that he served the claimant for 3 years, but his salaries for the period he served the defendant were not paid. The defense put forward by the defendant is that though the claimant was issued with letters of appointment as member 1 in Kum District Court, he did not serve as such to warrant drawing up salary from the defendant, as the 96 District Court were never constituted by the provisions of Section 131, subsection 132, 133 of the Evidence Act. It is clear that he who alleges and not one who asserts the negative must prove the assertion. In the instant case, the claimant asserted the positive that he was appointed member of Kum District Court and he served for 3 years and he is entitled to be paid his accrued salary in the sum of 912,000 naira. This means claimant has the burden of proving his assertion if he wants favorable judgment of the court to be rendered in his favor. It is only when claimant discharges the burden of proof imposed on him by law that the burden will shift to the defendant. See the case of Kate Enterprises Limited versus Dew. The claimant's claim being on unpaid accrued salary, he is duty bound to establish that he was employed by the defendant on a particular salary and that he worked for the period of claim. This is imperative since the defendants have denied the constitution of the district court, thereby maintaining that claimant is not entitled to salary as he did not work. The law remains that as between the employer and employee, the onus is on the employee to prove that he was employed by him on a stipulated salary and that he worked for the employer during the relevant period. It is for the employer to prove not only that he paid the said employee salary, but the claimant, in attempt to prove that he was employed by the defendant, tender SBC1 letter of appointment. The claimant will maintain that he was sworn in as member in Kum District Court by Patience D. 18 Esquire, Chief Magistrate Grade 2, who represented the governor at the inaugural ceremony. The claimant has front-loaded a document titled Address presented by Patience D. 18 Esquire, Chief Magistrate 2, at swearing-in ceremony of 2019 customary district courts. But refused to tender the said document at the trial. This means there is nothing to establish that the claimant was in fact sworn in as a member one to whom district court. This is because the law establishing district court but refused to tender the said document at the trial. This means there is nothing to establish the claimant was in fact sworn in as member one in Kum District Court. This is because the law establishing district court in Cross River State required oath of office of members of district court to be administered by the chief judge or the judge of the high court and not by magistrate. To make matters worse, the claimant has not tendered the oath which he subscribed to, if any, at the purported swearing-in ceremony. The law establishing district court has made ample provisions on the way and manner a member of district court can be sworn in and who can perform the swearing-in ceremony. I have no doubt in my mind from the pleading and evidence of the parties, claimant was by the Exhibit C1 offered appointment as member one in Kum District Court for a period of 3 years, but the claimant has not been able to establish that he was sworn in as a member of the court, of the district court as required by law, as there is no document tendered in evidence in line with the excellent provisions of Section 78 of the District Court Law of Cross River State, which governs taking oath of office as there is no documenting that evidence in line with the extant provision of Section 78 of the District Court, which I reproduce. The quoted provisions of the District Court law of Cross River State on oath of office is very clear and unambiguous. The section has made it compulsory that the oath of office be administered by the Chief Judge or a judge of the High Court and not magistrate, as in the case at hand. The claimant having been purportedly sworn by Chief Magistrate Court and not by the Chief Judge or a judge of the High Court has not been sworn in as required by law. This means the District Court has not been constituted, as the members of the court were not sworn in as provided by the law establishing the court. On claim that the claimant has worked for 3 years and handled several cases, the claim has also not been able Furthermore, having established that the claimant was not legally and lawfully sworn in as required by the District Court law, has no bias to sit and handle any case. If the claimant has done so, he does so at his peril. Let me also say here that tendering of Exhibit C10 is not helpful to the claimant's case, as it is incapable of establishing that the claimant served the defendant for the period of 3 years. All that Exhibit C10 can establish is that a demand of fee was made to the then governor of Cross River State for payment of stipend to members of the District Court. Also, considering the fact that Exhibit C10 was written 2 years, 10 months into the 3 years, also considering the fact that Exhibit C10 was written 2 years, 10 months into the 3 year, shows that something is amiss. Otherwise, how can an employee be working without payment of salary for 2 years, 10 months before complaining? This has gone to show that as claimed by the defendants, that Exhibit C10 was made for the purpose of this litigation. From all I have been saying above, the claimant has not been able to prove his case on balance of probabilities, and as there was no evidence to show that he actually worked for the defendant, since he was not sworn in for him to assume duty as a member one to whom this report. It is pertinent at this juncture to observe that the counsel for the claimant has made heavy wager on the need for court to strictly adhere to substantial justice. Let me say, courts no longer turn a blind eye to substantial justice for the sake of technicalities. The main focus of every court while deciding cases before it is to do justice between the parties and to itself. In doing so, the court ensures justice is done according to law and not sentiment, which by extension involves doing substantial justice and not technical justice. In other words, in doing justice, a court is to ensure that it is not parochial in looking at the justice from the perspective of one of the parties alone, even from the perspective of the parties, but also from the wider perspective of the court and the society at large. This is because justice is a concept wider than just between the parties, as the parties live in a society, and so a court needs to consider how the decision of the court will affect the wider society. See OK versus Pan Milk PLC. See also ED versus ASAP. It is clear to me that the haphazard way counsel for the claimant handled this case has contributed immensely in the way judgment of the court goes in this case. Counsel failed to diligently prosecute the case by bringing the relevant evidence needed for successful prosecution of the case. The claimant, having willfully failed to prove his case, he is not entitled to any of the relief sought. The claim is hereby accordingly dismissed for lacking in merit. I make no order as to cost.
As the court
As the court
pleases.
pleases.
Lord, we sincerely thank you for the judgment, and we'll be guided.
Registrar, any other matter?
No, my lord, that's all for today.
Okay.
That's all for today, my lord.
It's all right. Counsel, thank you for being with us. We have come to the end of today's virtual sitting. The administrator will continue. Thank you.
Thank you, my lord.
Thank you, my lord.